Good afternoon and welcome to our webinar. I'm Ron Jacobs and I'm here with Larry Norton. We co-chair the political law practice at Venable. We're excited today to be co-hosting this webinar with the International Stability Operations Association for our government contracts opportunities. So today we're going to talk about election year opportunities for government contractors and how that the various rules apply to government contractors. If you have any questions as we go, feel free to use the chat function in the webinar system. We'll answer those questions as we can as we go through the presentation. So there's sort of three broad areas that present risk for government contractors, and many of them present risk because, particularly when dealing with states or the federal government, the ways that you may develop other business or that you may interact with private sector clients are very different than the public sector clients, and some of these rules are a little less than intuitive. So the three broad areas we're going to talk about today are first, pay-to-play laws, which limit corporate and individual contributions to political candidates, and we'll drill down on how those apply to what could be individuals within the company who have no real connection to the sales function of the government. How the next one is one that surprises a lot of people, which is that selling to state governments can often trigger lobbying registration requirements. That's very important to make sure you understand what the rules are there. And then the third area is sort of where many traditional sales deals are made over dinner, over drinks, providing tickets. Those things are all very highly regulated at the federal, state, and local level when it comes to giving those gifts to government officials. So it's very important to understand what the rules are. And of course, the theme that you'll see throughout our presentation today is that when you're dealing with state and local governments, each of them has their own rules, and they're all very different. What is permitted in one state may be prohibited in another. What's prohibited in one state may have a special exemption that just simply requires disclosure of a gift in another state. So it really does vary widely as to how the rules apply and what gets done. So the broad way to think about mitigation and how to protect yourself against these risks is to understand the rules. So that's a good chunk of what we'll talk about today. Set up a plan for political giving, for lobbying registration, reporting, and overseeing entertainment expenses. Make sure that you have policies in place. And then, of course, the important piece then is to train your employees so that they know if they're moving into a new state, whether they have to register as lobbyists, if they can take someone out for lunch, or whether that's prohibited, and what kind of political giving has to be regulated and pre-cleared. So it's important to make sure you've got all those strategies in place. And once we talk about the particular rules, we'll conclude today with a discussion of sort of how to set up a compliance plan that's workable and that allows employees to engage effectively without hamstringing their efforts, but that will be fully compliant and not cause problems for you. So let's now start talking about our first substantive area, and that is the restrictions on political activity. As those apply, they're often known as pay-to-play rules. And so these are rules that basically the idea is that you prohibit making political contributions in order to get a government contract. There have been a number of scandals throughout the states and local governments where contractors have given contributions to political figures, perfectly lawful contributions under the campaign finance rules, but they've given those contributions and then they've seen an uptick in the number of government contracts they get. And so a number of state and local governments have created these pay-to-play rules that restrict political giving by government contractors and those associated with government contractors. Even if there's no intended link between the two, there may be perfectly permissible personal political activity, but it's now restricted under these pay-to-play rules. So Larry, you want to dive in on the pay-to-play?
Sure, thank you, Ron. As you see on this slide, pay-to-play laws really come in a few different types and sometimes more than one type. The most common pay-to-play restriction that you'll see at the state or the local level is a restriction on the making of political contributions, either altogether or subject to a certain limit that's lower than the limit that's available to other donors. And as Ron pointed out, those limits and restrictions may apply not only to the company but to certain associated individuals. Other states and cities require registration or regular reporting to the Board of Elections by the contractor. So it involves an interaction with an agency that government contractors don't typically deal with. But in many cases, the states and cities that have these kinds of laws require an updating of their own database with new contracts and reports on a quarterly or sometimes less frequent basis of political contributions that were permissible, but they want to have a place where there's more transparency about the contribution that was given. As noted there, the pay-to-play laws typically apply to the company, to owners over a certain ownership threshold, officers, and individuals who are involved directly in the contracting process or oversee the process, and usually subsidiaries and affiliates. And there are a couple of jurisdictions, Connecticut among them, that apply the contribution restrictions to children who are living in the same residence and spouses.
And I think it's an important point here is that while we typically think of political giving by those individuals as sort of their own business as long as you're not using company resources, these rules sort of sweep the personal into the company, and so it changes the paradigm for how you think about compliance when you're dealing with individual contributions.
Right. Certainly not intuitive to people that their personal political contributions could have serious implications for the company. And the next slide there on penalties really demonstrates just how significant those penalties can be. Pay-to-play laws really are distinct from other types of campaign finance or gift rule violations, which tend to create significant optics and reputational harm, but often the penalties are at the lower levels in terms of the money that has to be paid and fines. But pay-to-play laws really strike at the bottom line because in addition to fines, contracts can be voided if an impermissible contribution is made. Even relatively small contributions of $1,000, $2,000 can have the effect of voiding multi-million-dollar, multi-year contracts or causing the the awarding official to invalidate a pending proposal. And there are states that are very active in enforcing these laws. New Jersey is most prominent among them, and many of the cities and towns in New Jersey have invalidated contracts based on relatively minor, small political contributions that were made without knowledge of the law applying at all.
Yeah, there's one of the more well-known cases in New Jersey was a road paving contractor. The CEO made a contribution to one of the local political parties at the request of a friend. Had nothing to do with trying to win the contract, and they were, by all accounts, a good contractor. The state liked their work, and they were debarred. Their contract was canceled, and they were debarred from future road paving contracts.
Yeah, that case sent a real chill through the community, the contracting community, in particular, because I think in that case the president of the company realized the mistake and asked for the contributions to be refunded, and they weren't refunded until after a 30-day period, and the state Supreme Court said that 30-day period would be strictly enforced, and it was all too late. So, but quite a few engineering firms and other accounting firms, service industry firms have felt the wrath of the New Jersey law.
Yeah, there's another one, a bond counsel, where a partner in a different office made a contribution, and so they were disqualified from future bond underwriting work.
So the next slide highlights really the various ways that pay-to-play laws differ and may or may not apply to either individuals or contracts or particular periods of time, and all of them really have to be factored into a compliance plan in jurisdictions where you have a footprint, do business or have employees who may be at risk of making contributions. As we'll talk about in a moment, there are pay-to-play laws sometimes target specific industries, normally based on some history of some kind of corruption scandal. They usually apply to contracts that are awarded outside of the competitive bid process, but in some cases apply to all contracts. They differ in terms of the individuals who are subject to contribution restrictions, and in some cases the time periods differ. In a few instances, they actually apply the pay-to-play restrictions even beyond the expiration of the contract date, and we're going to dig into each of these in a moment.
And one of the other things, too, the activities that are covered, not only is it giving contributions, but also fundraising activities where people are raising money, hosting fundraisers, bundling, the kinds of things that sort of politically active people tend to do. It's not just the contributions, but also the fundraising activity that is covered. So the first area where the rules may differ from state to state are the types of contracts that are covered. And so, as Larry mentioned, a lot of times these apply to the no bid or the sole source kind of contracts because there's the most room for subjective intervention by government officials. But even in some states, fully competitively bid contracts require compliance with the pay-to-play rules. Will restrict people from participating in the process if they've made contributions within a window. Many bid contracts will require a certification that you've complied with the pay-to-play rules. It's oftentimes where a disclosure has to come into play, where you have to list contributions that have been made prior to the awarding of the contract. It's designed to try and bring transparency to the process, but in some ways, cynics would suggest that that's just a way for the government official to know who's given political contributions to them. Another distinguishing feature is often the value of the contract. So in some cases, people will, the state will require the pay-to-play rules in high dollar contracts, either on a per contract basis or sometimes a cumulative amount of contracts for people the whole way for all the contracts that a particular company has with the state. So it may be that even a series of small contracts, if you get above a certain threshold, $200,000 or some other number, that suddenly you'll be required to comply with the pay-to-play rules on the next procurement. And then the other piece to keep in mind is that there are particular kinds of contract or particular areas of contracting, whether it's particular industries, different goods or services, financial services to the state. We'll drill down on those a little bit more in a few minutes, but it can, in some states there may not be a general pay-to-play rule that would apply to all contractors, but there are in specific areas if you're maybe a lottery vendor or something, some special area where it can apply.
So we mentioned that pay-to-play laws are sometimes industry-specific, and gaming and lotteries, which are at the top of the list, have drawn a lot of attention for probably obvious reasons. But in some cases, the gaming industry has gone to court to challenge those laws, but they still exist in a couple of states. The challenge really has been based on the argument that there really isn't a predicate for applying stricter restrictions to officials and companies involved in that industry. But as more and more states have gotten into this space, pay-to-play laws have tended to follow. The other sort of general area where you see some very specific pay-to-play laws that are targeting industries are in some form of financial services, including insurance or bonds, and in many cases, financial services and retirement systems. Indeed, many of the major public pension plans and retirement systems have their own pay-to-play restrictions that apply independently of what the state and local law might be.
So as we've mentioned at the outset, there are different kinds of restrictions that come into play, and so it's important to understand that in what may be permissible, even in two states that have pay-to-play rules, one state may prohibit giving while another state may limit giving, while a third state may require disclosure. And so it's important to understand those restrictions. Typically if a person says, how much can I give to a candidate, they can go to the Elections Board website and find a chart of contribution limits. That may not be the right answer if you're a government contractor or an owner of a government contractor. There may be lower numbers that sometimes are very low, a couple $100s compared to thousands of dollars in other areas that would be allowed.
It's important to remember the last bullet there talks about disclosure of contributions, that with the internet and all these laws that require more transparency, make that information available online. And so there are a lot of eyes on what you're doing, a lot of scrutiny by not just the regulators, but by competitors and by watchdog groups, by trade magazines and others who are looking to try to connect the dots, as Ron mentioned earlier, between political contribution that may have been made either shortly before or shortly after the award of a significant contract.
Yeah, definitely. They're mostly available online, very searchable. People can find them and look all the time.
So again, a significant way that the laws differ are with regard to who the contribution is made to. So for the most part, pay-to-play laws will cover contributions to elected officials with some ability to influence the contract. And in most jurisdictions, that will include the governor and legislators and as well as other state officials, including the treasurer, in some cases even the state attorney general. There are a handful of jurisdictions where a contribution to any elected official triggers application of the pay-to-play law, and a small number of jurisdictions where contributions to the political parties can trigger the pay-to-play law. New Jersey has a provision that I think they refer to as a sort of anti-wheeling provision, and so the treasurer there will scrutinize contributions that you might make to a PAC that are then where the PAC has then made contributions to particular candidates and attempt to make the argument that the contribution was ultimately intended for an official who had some ability to influence the contract. And again, states approach this in just an endless variety of ways. In Connecticut, you can go online and the state is required to update the list of contractors who are subject to certain prohibitions based on contracts with the legislature or contracts with the executive branch. And in most other places, you're really on your own to figure out where your contracts may create, where you've got some bar or reporting obligation. And that can be burdensome when you don't really maintain information in the way that the states are asking you to keep track of it. For instance, whether you exceed certain thresholds and contracts with certain kinds of states.
I think it can present difficulties for companies if you're in multiple states. An employee in state A may say, I'd like to make a contribution to the governor. He's a friend, I support him, whatever it may be. And another employee, and so that contribution can be cleared. In state B, an employee may ask to make a similar contribution to someone running for governor, and it would be prohibited under the pay-to-play rules. Or the governor may be prohibited, but you can give someone running for the attorney general or different positions. It gets really complicated as to which ones are covered. And because you're now required to basically make sure that your employees are giving in compliance with the rule, that you really are sort of picking and choosing which candidates employees can support in their personal capacities.
This covered official issue also gets interesting in conjunction with federal elections, where you have state officials who are running for federal office. So Rick Perry, for instance, was running for president. There were restrictions on what certain companies and their individuals could give to Perry, not because he was running for president, but because he was the sitting governor in Texas.
Yeah, it gets very, very complicated that way. And then we've talked a bit about sort of the scope of the coverage, and again, it can really get complicated. When we think about political contributions at the federal level, generally companies themselves don't make contributions because corporate contributions are prohibited. But at the state level, many states allow corporate entities to contribute. Partnerships and LLCs make contributions all the time at the state and local level. And so the pay-to-play rules apply directly to the contractor, so the company that has the government contract. Some of them apply to any political action committees the company may have. So even if the company's been very careful, thinking, we want to go ahead and set up a PAC to handle all of our political activity, that may be okay, but in other states it may not be okay, that a PAC affiliated with a government contractor may be covered by the rule. And then this is where the pay-to-play rules really start to diverge, but also get down into the weeds, because what the laws are aimed at avoiding is someone affiliated with the company from making a contribution to get the contract. And so typically owners of a company are prohibited from making a contribution if they own a certain percentage. So if someone owns a few shares of a publicly traded company, that's not going to trigger the rule, but if it's a sort of a family business where there may be just a few owners, or a partnership where there's a few partners, then that would trigger the restrictions applying to the people who own the company. Then some states say, okay, we're going to take not only the owners, but also certain officers, the CEO, the president, certain other high-level officials, often sort of the C-suite type people. And then they, from there, they may go down below that and say also any employee who has responsibility for the contract, either who solicits responds to the solicitation, has the interaction with the government, tries to get the sale of the contract, or the people who have the day-to-day operations with the contract, who interact with the state to execute the contract. Then beyond that, spouses and children can be included. So this is one of the bizarre areas where you may want to stay out of your employee's personal business, but suddenly you have a request from the senior vice president that her husband wants to make a political contribution, and so you need to start clearing spousal contributions. So it gets to be a thorny area to wade through. And then because of the desire to avoid circumvention, affiliated companies are also covered. So if a subsidiary or a parent or a sister company may all be covered by these rules. And where it really gets crazy is when the individuals associated with the affiliated companies are also subject to the rules. So if you have a subsidiary entity where the officers there are also subject to the rule, that can get complicated to make sure you've got the right procedures in place and you've scoped out the right people to pre-clear their contributions. And then in a few states, Kentucky is an example of one where pretty much every employee is subject to the rule, so there's no circumvention there.
And finally, the last variable that we wanted to talk about is the duration of the contribution restriction or prohibition. And as we note there, that some of the pay-to-play laws have a look-back period before the contract is awarded, sometimes going back a year or 18 months, which requires contractors to look ahead and plan accordingly. So if you've historically done business with a locality or with a state, or you anticipate that you could do business in the coming years, it's important that your employees be educated and trained about the pay-to-play laws and understand what those restrictions are. The contribution could be made at a time where there's really nothing pending, but it could wind up invalidating a pretty significant RFP down the road. The restrictions, as we mentioned earlier, will generally apply to the pendency of a bid or a proposal, and usually will continue for the duration of the contract until the contract is fully performed. And that question can sometimes get a little murky. And then finally, some of the pay-to-play laws will extend beyond the performance for some period of time. In some cases, Philadelphia, I think, has a pay-to-play law that will continue in effect so long as the mayor or other elected official who was nominally responsible for awarding the contract is still in office. So they have a significant tail and sometimes quite a long lead time.
And the other thing, particularly thinking about some of the federal pay-to-play rules that we'll talk about in a couple of minutes for particular industries, the federal rule that applies to the state giving even applies to employees who move to the company. So if you have an employee who worked somewhere else and made political contributions, those contributions will be tagged to the new company. If in certain circumstances, it's a shorter window if they're not involved in the sort of the selling to the state. But that's one where the idea that you have to ask your potential hires what their political giving looks like beforehand is another area that most employers would never want to touch, but needs to be done to make sure you don't sort of get tagged with that contribution going forward. So we've now talked a lot about what these pay-to-play rules look like, and so you may be wondering where they exist. And so we've created this chart to try and divvy them up a little bit and kind of explain what's what. So the green states on the chart are ones that do not have a pay-to-play law. So there you don't have to worry about the states, although as we'll talk about in a minute, there may be localities within those states that have pay-to-play rules. So if you're contracting with a city in a state that doesn't have a pay-to-play rule, it still may be affected. The yellow states are what I call sort of the limited scope pay-to-play laws. So they could be limited in one of two ways. Either it's a law that like in California, where it's a really convoluted way that it applies only to certain state officials who are sitting sort of on other boards that may be making contract awards. So it's pretty narrow in how it applies, or it applies just to specific industries. Georgia applies to certain regulated entities like utilities. Florida is more financial services and law firms. It's a fairly discrete area. So if you're depending on what your business is, if you're an IT services firm or a road construction firm, it may not actually apply to you, but we wanted to highlight those as ones to look out for. And then the red ones are states that have pay-to-play laws that are broadly applicable to contracts in pay-to-play laws where there are either prohibitions or limitations on giving. And then finally, there's a couple of states, Rhode Island and Maryland in particular, where it's only a reporting requirement. There's not a prohibition that goes along with it. So we wanted to try and distinguish which states are which there. So again, this is sort of an overview, and keep in mind this is a snapshot in time. States change their laws. We're in the middle of a legislative session in a lot of places, so you never know when these might change. But this is just to give you a sense. And of course, some of the big, fairly active government contracting states, Ohio, New Jersey, Illinois, are ones that have these rules in place. So it's important to remember how those apply.
So our next couple of slides point to how the state laws apply and where some of the significant local pay-to-play laws exist. Important point here is that a state pay-to-play law may apply to state contracts only, that is, contracts with the state of Illinois, for example, and to state agencies, or the state law may apply to local contracts, as it does in the list of states you see here. There's kind of as an asterisk, New Jersey is, we've mentioned a couple of times, is a jurisdiction where the state law applies to local contracts, but localities, townships, and cities are permitted under the law to adopt their own pay-to-play law, that so long as it is at least as strict as the state law. And many, many local governments in New Jersey have done exactly that. So, again, if you're dealing with the municipality, cities and counties, you need to be sure not just to look at their laws, but to look at the state laws as well. Many major municipalities have their own pay-to-play laws, and if you look here, you can see that you've got some very large states, including New York and Texas, that have no state pay-to-play law that applies to state government contracts or local government contracts, but Dallas, Houston, San Antonio all have their own pay-to-play laws that apply to municipal contracts, and New York City has a pay-to-play law that requires that imposes lower contribution limits as well as reporting. California is another state with a statewide pay-to-play law that is very limited in scope, but cities, including LA City and County, San Francisco, and a number of other counties recently in California have added similar pay-to-play laws. Cook County, Chicago, very aggressive and different looking pay-to-play laws than the state law that applies in Illinois only to state contracts. So again, a lot of variability here.
So now we thought we'd talk a little bit about a couple of specific state laws just to give you a sense of what they look like. So Ohio has a pay-to-play law that does not apply to competitively bid contracts. So that's an important carve-out, obviously, for the kinds of contracts that are covered. But once you take out competitive bidding, any contract worth more than $500, so a very low dollar threshold, comes into play. And the rule is one that restricts the amount that may be given to various officials, and it applies, as you can see, fairly broadly on the scope. So the entity that holds the contract, whether if it's an individual that has the contract or a company that holds the contract, then partners, shareholders, administrators, executors, trustees, and then any spouses of these individuals are also covered by the rule. And they prohibit giving more than $1,000 to a public officer who has ultimate responsibility for the award of the contract or to that person's campaign within 2 calendar years. So again, that's a look-back period of 2 years. So what that means, if you think about it, is that if you had a partner at a firm make a political contribution a year ago to a gubernatorial candidate, and then you decide you want to move into the state and you were working on not a competitively bid contract, you would be precluded from receiving that contract because it's in that 2-year period. The way the rule works, looking at the ultimate responsibility of the award of the contract, what the rule says that if the governor appoints the person responsible for making the contract decision, then the ban applies to the governor. Ohio does not have a reporting obligation. And also, Ohio excludes political action committees that are affiliated with the company. So while the company may not make a contribution, and those individuals affiliated with it may not make a contribution, the Secretary of State has said that a PAC created by one of the companies can give. So it's kind of an odd carve-out in many ways that doesn't make a lot of sense, since the PAC would likely be funded by all those people who would be prohibited from making the contribution directly.
So Maryland is a state where the law has changed and then changed again and changed a 3rd or 4th time, all just over the last few years. The state legislature strengthened the law considerably a couple of years ago, and the Board of Elections has been through a few rounds of rulemaking in an effort to bring some clarification to the statute. Maryland had a pay-to-play law and has had one for quite a long time, but it all went online just a few years ago. And there have been a lot of growing pains as our clients who do significant business in Maryland have struggled to understand just how the law applies. Again, as Ron noted, Maryland is a disclosure-only state. There are no limits, no lower contribution limits, no outright prohibitions on contributions, but the reporting is pretty extensive, and it includes not only, as you see there, contributions made by various affiliated individuals and entities and the PAC of a government contractor, but also requires the contracting entity to update the database with new contracts within a particular period of time. So it's inserted the Board of Elections into an area that it knows little about, and I think explains why the law has been difficult to administer. One of the interesting things about the Maryland law is that it imposes a very specific due diligence requirement on government contractors for the CEO or authorized representative to do certain specific outreach in a certain form to individuals that you see listed there and entities to ensure that all the contributions, personal contributions that have been made that may not yet appear on the state's, on the reports filed by candidates and others, are properly reported by the government contractor. And Maryland builds in an exception where the company or organization has a policy in place, a written policy that is generally distributed to covered individuals that prohibits them from making covered contributions. And that, we'll talk later about how to approach compliance in this and other areas, but it creates it's a sensitive question in some organizations. It raises unease about First Amendment concerns, but the state does allow for an opt-out. And of course, in other jurisdictions where contributions could cause the loss of a contract entirely, it's tempting. And certainly some of our clients take the position that they simply don't want covered persons making contributions in certain jurisdictions because of the high risk. So
the last state we'll take a look at is New Mexico. It's similar to Ohio in its scope, and but it also, like Maryland, includes a disclosure element to it. So it applies to contributions made during dependency of the procurement process or during negotiations in a sole source. So what they say is that's from the date that the announcement is made that the contract is going to be out for bid up through the award of the contract is when the contributions are prohibited. It applies to contributions to the official who has the authority to award or influence the award of the contract. And again, like Ohio, it has a fairly broad sweep in terms of who's covered by the rule and who's prohibited. And then the disclosure piece is anyone who's given $250 or more in a 2-year period, any of those covered individuals, you have to disclose the amount, the date, the nature, and the purpose of the contributions that they made when submitting the bid. So that sort of, again, requires, with a 2-year look back, it's a lot of record keeping that has to be done. And so you may be able to pull those records together sort of as you're submitting the bid, but if you know that you're moving into New Mexico going forward, that may be something to start, add that to the list of states where you're pre-clearing contributions, so at least you have the record of those contributions as you go. So again, it's sort of another flavor for these different kinds of states. So we've picked sort of 3 states just to give you some samples. The one state that we didn't talk about specifically is New Jersey, because one of the reasons I don't like to talk about it is because that rule is so convoluted that it's hard to boil down to a webinar in many ways, and that it's important to really understand the details of that in particular.
Yeah, it's interesting. The executive director of the New Jersey Election Law Enforcement Commission routinely, at least a few times a year, issues a plea to the legislature to simplify the pay-to-play law and to harmonize the patchwork of local laws that apply there. And so far, those pleas have landed on deaf ears.
Yeah. Even the regulators' webinar doesn't really explain the law very well in terms of what's required and what disclosures are made. So that's a sample of the states' pay-to-play rules and how they look. So now we'll turn to talk about the federal pay-to-play rules.
So the FEC, Federal Election Commission, enforces contribution restrictions and prohibitions on certain categories of entities that may not make contributions under the federal campaign finance law. And most people are aware that corporations are prohibited from making direct contributions to candidates for the House of Representatives or Senate or for president, but there is a separate prohibition in the law on government contractors contributing to campaigns. Now, as a practical matter, that prohibition hasn't added a lot to the law because the corporate prohibition already exists. But unincorporated entities or sole individuals who are involved in government contracting are subject to prohibition, may not make any contribution whatsoever to a federal candidate. That prohibition applies only to the contracting entity, though, and so in the category of huge, loopholes, it really doesn't really impose much of an impact. Unlike a lot of the state laws we've talked about, the federal law does not apply to principal owners or officers or other individuals who may work for or own in some part a government contracting entity. And it also doesn't apply or prohibit government contractors from having PACs, and most of the large government contractors have exactly that, and they raise contributions from individuals, and they give contributions through the PAC rather than through the incorporated entity. So again, the only entities that are individuals that are affected by the federal rule are sole proprietors, LLCs, and partnerships. Independent expenditures, which are disbursements made by an organization that are not coordinated with a candidate or a political party, and historically have included ads primarily, but could include any sort of expenditure to try to influence an election, are barred, prohibited by federal contractors. So just like federal contractors can't make direct contributions, the law prohibits them from making these so-called independent expenditures. Questions have been raised about why that should be so, given the Supreme Court ruling in Citizens United that corporations may make independent expenditures without that it's unconstitutional to apply the corporate ban to corporations. But the law hasn't changed, and the Federal Election Commission has interpreted the law and the Supreme Court decision as leaving the ban on federal contractors in place. This doesn't often raise concerns for government contractors directly, because few of them are going to make independent expenditures in their own name, but some may be inclined to give contributions to super PACs that aggregate contributions from corporations and from individuals and make independent expenditures. And there have been some well-publicized and embarrassing circumstances where a government contractor, a federal government contractor, has given some money to a super PAC, and the report, of course, is public, and then a watchdog group or someone else notices that the federal government contractor made a contribution that they were not prohibited to make. So they not only can't make their own independent expenditures, they can't give to a super PAC that aggregates money and makes independent expenditures.
And I think one of the things that most super PACs have lots of information when they're soliciting contributions that say we can take unlimited individual and corporate contributions. And some of them that are careful will point out that they can't take federal government contractor contributions, but not all of them think that through. And so it's important to make sure you do your own due diligence, even if they say they can take corporate funds. If you're a government contractor, make sure you know what they're going to use it for, and not give if it's going to be used for independent expenditures. So then, to finish up the discussion of pay-to-play, and particularly at the federal level, there are special federal rules that apply that a few different agencies and self-regulatory bodies have put into play that, although they're federal, they apply to state candidates. So the first one that's been in place for a long time, the Municipal Securities Rulemaking Board, the MSRB, if you are an organization, a law firm, a bank, or particularly banks, financial services institutions that underwrite bonds, the MSRB rule applies and prohibits making contributions to local candidates or state candidates who have the ability to influence those decisions. Then a few years ago, the Securities and Exchange Commission came out with a rule for investment advisors. And the way that rule works, it applies to investment advisors who advise funds where a government entity is invested in those funds. It's kind of a little convoluted the way that works, but what that means is a public pension fund or a state retirement account where you're on a menu of options for employees to invest in as part of their retirement, those rules apply. And so what they say is that there's a 2-year look back on contributions by covered associates, which is its own particular term of art, but that it's similar to kind of the list of people we've talked about before, and the officers and those responsible for the contract. If you make a contribution, then the state's not allowed to invest it with your fund. And so these rules are very complex. They're in addition to the state rule. So even if the state has a rule that allows for certain contributions to political people affiliated with a pension fund, the SEC rule applies sort of on top of that in addition to. So you've got to make sure you're complying with both the state pay-to-play rule and the federal pay-to-play rule. So if you're in the financial services business dealing with states, keep in mind that even that map where there were green states, the federal rule still applies even in those green states. So it's important to remember how those rules work. And this is the one in particular where a sitting state official, you're still prohibited from giving to that person if they're running for a federal office. So the state laws are preempted when you're dealing with pay-to-play rules and federal candidates. So if a sitting governor is running for Senate in a state that has a pay-to-play law, the pay-to-play law doesn't prohibit giving to the federal campaign. But the federal, these MSRB, the SEC, the FINRA rules, if you're in that bucket of contractors that are covered, a contribution to a sitting governor to his or her presidential campaign would be implicated by those rules. So it's important to really think ahead and think in sort of a couple different dimensions of how they all fit together. If you're particularly interested in this, it's more, as I said, related to sort of the different financial services type entities, and so we cover those in some other webinars we've done before on financial services restrictions. So that's our overview of the pay-to-play rules, and now we'll flip over and talk a little bit about how the lobbying rules come into play.
Yeah, we'll come back to compliance strategies that really overlap, I think, a lot of each of the areas we're going to talk about. We'll touch on that at the end, but the next significant risk area we wanted to talk about is sales and procurement, and we frequently hear our clients say, we sell, we don't lobby. And one of the traps that state and local government contractors fall in is expecting that the state lobbying laws track traditional notions of lobbying. And when people think of lobbying, often what they think about is going down to the State House and meeting with legislators or staff and trying to get a bill passed or stopped or amended. But the states have taken a very expansive, some might say creative approach to defining lobbying to cover all kinds of activities, some of which were not really outside the scope of this presentation, but reach as far as cultivating goodwill, but in many cases apply specifically to procurement activity and indeed under state and local laws that are called procurement lobbying statutes. So the question for the government contractor is whether the interaction that you anticipate making with the state officials regarding their purchasing decisions is defined as lobbying under the state or local law. And again, those requirements are going to vary very much from one state to another. In many places, there is a distinction between routine sales activity and really shaping a major procurement or a request for proposal. In many cases, there are carve-outs for the formal process of applying, submitting a written submission or coming in for a conference that's part of the formal award. But in a lot of states, the early process, the talking up the product, the trying to encourage government officials to issue the RFP in the first place can fall under the definition of lobbying.
And in some of the definitions where they do carve out the sort of the routine sales, it's not at all clear where the line is there, because the law says any attempt to influence a purchasing decision but not bona fide sales activity. And so trying to determine whether you need to register or not can be very, very tricky in some of those jurisdictions.
The federal enforcement of the lobbying laws has been notoriously weak, and again, this is an area where familiarity with the federal law can breed complacency in regard to the states that is not appropriate. Many of the states are quite aggressive in enforcing their lobbying laws and applying fines. You may have read in the last year in Illinois, a number of companies had sent emails to Mayor Emanuel's personal email account, and the state regulator subpoenaed those emails and has issued fines against a number of those companies. There have been front-page stories in Illinois about lobbying. So it's important to understand that this is an area, unlike the federal law, where the law changes a lot, often in response to some scandal or perceived scandal, and that states pay a lot more attention to the enforcement and have more resources to enforce than the federal government has allocated for this purpose.
I think it's also one where, because the states are smaller than the federal government, people notice when people are, if they're walking the halls of the state house or of government agencies. And some states have rules where you have to register and get a badge to be a lobbyist and things like that, and they really do ask the question, why aren't you registered if you're not there? So just a couple of states to go through here to kind of give you a sense of how these rules work. So the definition of a lobbyist in Georgia includes any individual who is employed or retained to influence a state agency in the selection of a vendor to supply goods or services to a state or local government unit. And then state agencies are defined to include local political subdivisions of the state. So again, here, it's a good example of where there's fairly clear language that people who are engaged in these activities that would be very common for government contractors, trying to convince the state that they should buy their products or services, would need to register as lobbyists in Georgia. So keep that in mind. Another big state, New York. This is one where the rule sounds very broad. Any attempt to influence any determination by a public official or by a person working in cooperation with a public official related to government procurement. Now, the New York law then goes on to exclude certain things like participating in the formal process. So if you're responding to an RFP, some of those bid conferences, those things are excluded. But the key takeaway is that New York is one of those states where if you're in early in talking about things before the procurement begins, trying to shape the procurement, that's lobbying under New York State. And New York City has similar rules as well. So if you're selling to the to the city of New York, you very likely would need to register as both a city and a state lobbyist in New York because they have a bizarre overlap of their lobbying rules there.
One thing to bear in mind about these state laws is that, again, unlike the federal law where there's a threshold of activity before registration is required, many states and cities have very low thresholds or no thresholds at all. In some cases, registration is required before even an initial phone call or meeting. And so the time to think about whether these lobbying laws apply is not after the meeting with the government official or even the day before, but it's in enough time to make sure that if you need to register, you do.
And the other thing, too, is a lot of the thresholds, New York is an example of one where the threshold is tied not to a percentage of time or a number of hours, but tied to the amount of compensation a person receives for lobbying. So if you have a senior official that's going to parachute into New York to have a meeting who has a very high hourly rate, then you may cross that threshold very quickly, whereas you could have a lower level employee maybe working more time there before they would have to register. So you have to think strategically about whether the CEO is actually going to go into New York to meet with the people, because that might trigger registration itself. Just flipping through again, sort of Texas is another state that defines lobbying to include administrative action, which includes matters relating to the purchase of products or services by the agency. So again, in Texas, a state that you might think, a little looser in some of its regulatory framework, does include procurement functions in the definition of lobbying. And then we've focused on states, but also local governments have a lot of requirements to register as lobbyists. I mentioned New York City, but there are other major cities that have lobbying ordinances, and those often include procurement activities that are covered as well. So it's important to check local rules as well. So our last sort of issue area to talk about is entertainment. So when you're taking people out for dinner or lunch, giving them tickets, things that you might typically do in a sales context when you're dealing with government officials, that is different. And of course, if you're a longtime government contractor or that's your primary business, you may be used to some of these rules. But if you're a business who is thinking about government contracting or expanding in the government contracting space, it may look very different for how you engage in these activities compared to what you do in the private sector.
So the definition of a gift almost universally is anything of value. And it typically these gift rules will apply to food and beverages, tickets to sporting events, payments for travel, allowing a member of the state legislature to spend 2 weeks at your beach house, and even trinkets like note cards and signed photographs and T-shirts and things like that. But as you can imagine, there are all kinds of exceptions that the legislators have written into the laws to try to allow some gift giving. Those aren't necessarily intuitive, but it's important that anyone, and we'll talk in a moment about compliance, but really anyone who has any degree of interaction with officials, with government officials, and that almost always includes C-suite and other senior officials, understands that these rules apply, that they vary considerably, and that even relatively de minimis expenses, a cup of coffee, may not be prohibited. A single drink may be something that would trip a problem with the gift rule, and if you do make that gift, that you try to correct it as quickly as you can. Again, as with the procurement lobbying laws and the pay-to-play laws, each state has its own rules. Lots of exceptions exist. Some of them are absurd and very specific. Some are more general, and some are dollar amounts. There are often special rules for government contractors that are more restrictive than the gift rules that apply ordinarily to individuals. And in many cases, the gift rules for gifts to legislators and their staff are different than the rules that apply to executive branch officials. At the federal level, the current president and President Obama each applied more stringent gift rules to their political appointees than to the rank and file in the executive branch. So you have multiple levels of gift rules that apply.
Another thing to kind of keep in mind with the gift rules is that some of those vendor rules are very restrictive. They may apply only to certain people within the organization. If you have registered lobbyists, the gift rules may change. It really varies in scope widely, and you really have to be prepared to deal with the differences in the rules. And the same activity in one state could lead to restrictions that could be prohibited in another state. So you really have to know what the rules are in any particular state.
Normally, the gift rule, some type of gift rule, is going to cover all public employees and elected officials. And a thing to be careful about is that in many cases the law will apply if that official suggests that you make a gift to a third party. So I can't use the tickets for that Super Bowl, but why don't you give that to my cousin? Exactly.
Yeah. So you have to be very careful. And then the last thing I would say about that is that a lot of states, particularly the elected officials, don't know their gift rules nearly as well as they should, and so you can't rely on them to say no. Basically, if you say, hey, let's go out to dinner, they may accept your dinner and not appreciate that that's against the rules. So know the rules ahead of time so they can be prepared to comply rather than relying on the state official as an important tool. At the federal level, they know their gift rules pretty well, but at the state level it can vary widely. And I've seen situations where there have actually been gifts solicited by government officials that are prohibited only because the company knew what the rules were they able to kind of talk that person off the ledge there. And one other thing to keep in mind about gifts is that while the gift rules allow for certain kinds of gifts to be given, you can never give a gift in exchange for official action. So you can't, even if a gift of $100 may be permissible under state gift rules, you can't say, gee, thank you for awarding that contract, here's a gift for $100, or if you give me the gift, or if you give me the contract, I'll give you this gift. Those are all prohibited under the bribery laws.
I mentioned a moment ago that requests that gifts be made to third parties, like giving the tickets to the cousin. Probably a more common scenario for government contractors, particularly engineers or architects, are the requests that the firm make some contribution to the library or for a parade or for something else in conjunction with a building that the contractor may have been significantly involved in. And in many cases those are permissible, but in some they are not. One area to be very careful about are requests to make contributions to tax-exempt organizations where the requesting official may sit on the board of the organization, and there are a number of jurisdictions that bar the official from receiving a gift, even though the gift might be going to some third-party organization. So and also I think important to keep in mind that even though many of these prohibitions apply to the public employee or the elected official and not necessarily or always to the contractor, the reputational risk to the contractor is significant. And the last thing any government contractor wants to be is caught up in somebody else's scandal.
Exactly. So we've now given you lots of warnings about all the areas where you can trip up. So let's talk now about how to solve the problem and how to design a plan. And I think the first part, particularly for government contractors that have a broad geographic footprint, is identifying the markets. And when we were talking about the pay-to-play rules, that look-back period can be very difficult. You have to anticipate where you want to be in 2 years and know not to make political contributions there in certain circumstances. So step one is just take the map out, color code it. Where are you? Where do you want to be? What kind of contracts do you have? Are they typically no-bid contracts, or are you in an area where they're sealed bids, so they may be less likely to apply? What are the ways you want to market to different officials? You know, are you used to sort of private sales, and so dinners and entertainment is used, or are you a longtime government contractor and you kind of know how to do those rules, how to do things? Are you going to put on seminars? What are you going to be doing so that you can, in each of those places, so that you can figure out how to build the program to comply with that?
And hand in hand in that, of course, is, you know, where are you? Where are your plants located? Where are your offices located? It's impossible to police every employee, and in some cases spouses and children of every employee with regard to these laws. But when you're attempting to look at where your risk is most significant, look at where you are and where you're likely to interact with government officials.
Exactly. And so then the next steps are sort of designed to cover each of these different areas we talked about. With the pay-to-play rules, once you have your map of the country designed, then start figuring out, okay, if we're in certain states with pay-to-play rules, who are the covered employees? Are we talking about the CEO? Are we doing work in Kentucky where we've got to deal with every employee? Do we have board members that are covered by this? Who are the employees? And then the flip side is, which are the officials that are covered by that rule? So maybe it's just the governor in that state, or maybe it's local officials. And then this is where the rubber hits the road, is to figure out, are you going to ban employee contributions? Are you going to develop a pre-clearance process? What's that mechanism going to look like? And typically what we suggest is sort of setting up the scope of who's covered, pre-clearing those contributions. So if you're in states where it's executives only, you say to the executives, look, if you want to make a political contribution, we'll do our best to let you do it, but you need to let us know beforehand, so we don't have that New Jersey situation where you make a contribution to a political party and suddenly you're barred from a contract. Give us as much lead time as you can, but promise to turn them around quickly, either depending on how large the operation is. Maybe there's a separate email address that people can forward contribution requests to, or a particular person in the compliance department who can then check and figure out if the contributions are okay. And again, helping to educate the employees to know, gee, it's not just me, it's also my spouse that I've got to pre-clear these contributions for. And then one of the advantages of the pre-clearance is not only that you don't make impermissible contributions, but you also have a record of the contribution. And so it's useful to then go back to the person and say, okay, you're allowed to make a contribution of up to $250 there. You can't make the full $3,000, but you can do $250. Let us know when you make that contribution so we can put it on our chart, and we know when we've got to file the disclosure report that we've got it made. So that's sort of how to think through some of the pay-to-play issues.
And a lot of this will depend on your business, how much of your business relies on government contracts, and how significant it is in particular jurisdictions. There are some approaches that can help simplify compliance here. For all the jurisdictions that have pay-to-play laws, there are a certain group of individuals who are subject to almost all of them. And that includes owners over 5%, 7.5%, 10%, significant owners. Officers are almost always covered, and very senior officials who are directly involved in the government contracting process. And you may want to simplify things and say, look, wherever you make a contribution, your contributions are going to need to be pre-cleared, even if that's not a large universe of people, so that they're not struggling if they're politically active with the rules in one state or another.
Absolutely. I think that's very important. In simple for the employees is better, is what we've found. On the compliance side, you can have a sort of a dashboard type tool where if you've highlighted certain states where either you're not going to be active or where there aren't pay-to-play rules, the employee can say, hey, can I make a contribution here? And you can say very quickly, yes, that's a green state. We don't have to worry about it. You can make the contribution. Other states where maybe it's a red and it's a more, no, you can't make the contribution. And then there will be some in the middle if it's yellow, and that's where you have to do sort of a case-by-case analysis. But you can turn them around to the employees and put it on the compliance department as opposed to the employee to make that determination.
Well, educating employees on gift rules and in some cases on pay-to-play and lobbying rules is really crucial, I think, as a cornerstone of compliance. It's important not to turn people into experts on any of this, but to sensitize them to the point where they understand there's an issue. It's important to do it on some regular basis, either annually or every couple of years, because these laws change a lot. And it can be really important when you're sitting down with a regulator or receive that request for information or even a subpoena because someone just misunderstood what they were permitted to do, to say that you have a reasonable compliance program in place, and almost any compliance program will have to start with education. And so we strongly recommend that there be periodic training. We do a lot of that for our clients and in conjunction with our clients, that employees understand that how the engagement process works with government officials and what laws apply to them, and that there be a pre-clearance process for entertaining government officials. We do a lot of work at the federal level on the travel rules, because they require a lot of interaction with the entity that might be paying to get a member or a staffer to a particular event somewhere. But important that you allow some lead time. In many cases, the government official may be able to accept your invitation to travel to an event, but they need some time to get pre-approval from within the agency. And so what we like to say to our clients about most issues, and this is no exception, is that with some advanced planning, there's generally a way to get there. You may need to tweak exactly what you want it to do, but you can get there if you think about it and have some sort of process for it in advance.
Yeah, and it's if you don't have the pre-clearance process, then it can be too late to get it done the right way. So that's why it's important to think about it ahead of time. And as you again focus on the gift rule piece of this, make sure you think about what your engagement process looks like. Are you going to be putting on seminars? Then you can put on a seminar and design it to comply with the gift rules in various states. But you can't do that after the fact. So that's why it's important to think ahead on these things.
Lobbying compliance is another area where calendar and advanced planning is really crucial. It's important to know where you anticipate interactions, whether there are those thresholds we talked about before or no thresholds at all, and if there's reporting, that you are, ensure that you are collecting the information that you're going to need to report. And we can't really underscore this enough. One of the recent areas of regulation that has cropped up in response to the, Me Too movement has been a number of states that are now requiring organizations that hire lobbyists or have employees who are lobbying to make certain certifications with regard to their anti-sexual harassment policies. And so Illinois, for example, requires anyone who's lobbying in that state to certify before they can even register that they have a policy in place that complies with various elements of what Illinois thinks is an appropriate anti-sexual harassment law. And so this is hard stuff to sort out on the fly on the day that someone is literally on the way to Illinois or preparing to have a meeting. And so advanced preparation is important.
Another thing on the lobbying compliance side is that a number of states say that lobbyists may not receive compensation that's tied to the award of a contract, contingent compensation. And so there's this interesting feedback loop where a sales employee may not be subject to that restriction, but if they become a lobbyist, then the contingency fee ban applies. So you may have an employee whose compensation is contingent upon receiving contracts, or it's performance-based compensation. If that employee becomes a registered lobbyist in a certain state, that may be technically illegal, and so you have to think through what that looks like. Can that employee register as a lobbyist in that state if that's the compensation model? So again, that's, pre-planning is very important in that regard, and there are ways to design the compensation structure to kind of work around that, but you do have to be careful about that. So now we'll open it up to questions. If anyone has anything, feel free to enter into the chat room. We thank you very much for joining us today. We hope it was helpful and gives you some good ideas for how to come up with your compliance. A reminder that our next government contracts webinar will be coming up on April 17th, the evolution of Escobar in 2017 and the False Claims Act in 2018. So when things to keep in mind there. So thank you again. We really appreciate it, and hope this was helpful.
Thank you.